Hello, Patriots. There's been a lot of buzz lately on social media about free speech and a lot of misunderstanding. The First Amendment guarantees that Congress shall make no law abridging the freedom of speech. But for government employees, this right exists in tension with the government's interest in maintaining effective and efficient service. Over the past half century, the U.S. Supreme Court has shaped a nuanced framework for balancing these competing interests. This video traces the evolution of free speech protections for public employees, beginning with a landmark case of Pickering versus Board of Education, 1968, and culminating in the current legal landscape. Hi, I'm Dr. Ken Henry, and this is Conservative Commentary, where we spread the MAGA message. Before we dive in, please like, comment, share, and subscribe. This really helps us grow and get the MAGA message out. Now let's start with Pickering versus Board of Education, 1968 case from the U.S. Supreme Court. This is the case that provides the foundational balancing test. In Pickering, a high school teacher was fired for writing a letter to the local newspaper criticizing the school board's handling of budgetary matters. In particular, Pickering complained that the board spent too much money on athletics and not enough on academics. The Supreme Court reversed the dismissal, holding that public employees do not relinquish their First Amendment rights simply by accepting government employment. The court introduced a balancing test. The employee's interest in commenting on matters of public concern must be weighed against the government's interest in promoting workplace efficiency and avoiding disruption. Crucially, the court emphasized that speech on public issues, especially when made outside the workplace, deserves strong protection. Pickering established two key principles. First, public employees retain First Amendment rights. And second, that these rights are subject to a balancing test between the employee's speech and the employer's operational interests. Now, in 1983, the court considered the case of Connick versus Myers. Interestingly, this Connick was the Attorney General for New Orleans, was Harry Connick Jr.'s father. This case defines what public concern is, sort of. Now, the next major development came in the Connick versus Myers case, where an assistant district attorney was fired after distributing a questionnaire to colleagues about internal office policy. The court held that most of the questions did not address matters of public concern and thus were not protected. Connick narrowed the scope of protected speech by introducing a threshold inquiry. Before applying the Pickering balancing test, courts must first determine whether the speech addresses a matter of public concern. If it does not, the speech receives no First Amendment protection in the employment context. This case clarified that, first, speech must relate to political, social, or community issues to qualify as a public concern. Internal grievances or personal disputes generally fall outside First Amendment protection. Now, in 2006, the Supreme Court considered the case of Garcetti versus Sabalos. This is the, quote, official duties limitation case. In Garcetti, a deputy district attorney claimed retaliation after writing a memo recommending dismissal of a case due to prosecutorial misconduct. The Supreme Court ruled that speech made pursuant to official duties is not protected by the First Amendment. This decision marked a significant shift. Even if speech touches on a matter of public concern, it is not protected if made as part of the employee's job responsibilities. The court reasoned that the government has greater latitude to control speech it has commissioned or created. Garcetti introduced a new limitation. Speech made pursuant to official duties is categorically excluded from First Amendment protection. Now, this really has had profound implications for whistleblowers and professionals whose job involves speaking on public matters, such as teachers, prosecutors, and auditors. In 2014, the Supreme Court considered the case of Lane versus Franks, and this clarified the scope of Garcetti. In Lane, a public employee was fired after testifying under subpoena about the corruption he uncovered while managing a government program. The Supreme Court held that his testimony was protected speech because it was not part of his official duties. Lane clarified that truthful testimony under oath, even if related to job duties, is protected if not required by the job. Garcetti does not extend to all speech related to employment, only speech made pursuant to official duty. This case reaffirmed the importance of protecting employees who speak out as citizens on matters of public concern, especially in judicial proceedings. In 2016, the Supreme Court examined the case of Hefferman versus City of Patterson. This is a case that considered protecting perceived speech, not real speech. In Hefferman, a police officer was demoted for allegedly engaging in political activity. What was it? He picked up a campaign sign for his mother. He had not actually supported the candidate. The Supreme Court held that the demotion violated the First Amendment because it was based on the employer's perception of protected speech. This case expanded protections by focusing on the employer's motive. Government action based on perceived speech or association can violate the First Amendment, even if the employee did not actually engage in protected activity. So what is the current landscape? Today, the legal framework governing public employee speech involves a multi-step analysis. First was the speech made as a citizen or as part of official duties. If made pursuant to official duties, under Garcetti, it's not protected. Second, does the speech address a matter of public concern? If not, under Connick, it receives no First Amendment protection. Third, does the employee's interest in speaking outweigh the government's interest in workplace efficiency? If yes, under Pickering, the speech is protected. Fourth, was the employer's action based on perceived speech or association? If so, Hefferman, it may still violate the First Amendment. So here's some practical guidance for government employees. Given this complex legal terrain, government employees should consider the following when exercising free speech. First, speak as a citizen, not in your official capacity. Use personal time, personal devices, and avoid invoking your job title or role when commenting on public issues. Focus on matters of public concern. Speech about corruption, policy, public safety, or community welfare is more likely to be protected than personal grievances or workplace disputes. Avoid disruption. Even protected speech can be outweighed by the government's interest in maintaining discipline and efficiency. Be mindful of tone, timing, and context. Understand your employer's policies. While constitutional protections exist, internal codes of conduct, ethics rules, and confidentiality agreements may impose additional constraints. Document retaliation. If you believe you've been disciplined for protected speech, keep records and seek legal advice. Courts will examine motive, timing, and consistency of employer action. Now, here are some emerging issues. Social media and political speech provide modern challenges, including the rise of social media. It's permeating the entire landscape now, and increased political polarization. As we all know, this country is deeply divided. Courts are grappling with how to apply Pickering and Garcetti to online speech, especially when employees comment on controversial topics outside work. Some key considerations include whether the speech was made as a private citizen, whether it disrupted workplace operations or undermined public trust, and whether the employee's response was motivated by the content of the speech or its impact. Recent cases suggest that off-duty social media posts on public issues may be protected, but inflammatory or discriminatory remarks, even if made privately, can justify discipline if they impair the agency's mission. So in conclusion, free speech for government employees is not absolute. It remains a vital constitutional protection, however. From Pickering's balancing test to Garcetti's duty-based limitation, the courts have crafted a framework that seeks to preserve democratic discourse while respecting the government's need for effective service. Government employees who understand these principles can better navigate the risks and responsibilities of speaking out. Whether advocating for reform, testifying about misconduct, or engaging in political debate, the First Amendment offers a shield, but only when wielded with care, clarity, and purpose. What are your thoughts? Let us know in the comments.